If a legislative body enacts a law requiring viewpoint neutrality in some area, and it does so because it is concerned that people who express a particular viewpoint are suffering discrimination, is that law unconstitutional on the ground that the intent of the legislative body was to benefit a particular group?
No, I don't think that that kind of law would immediately be unconstitutional. And again, I think if it's structured like a generally applicable public accommodations law, there might be important or significant governmental interests in being able to protect against that kind of discrimination.
Unless there are any further questions?
Can I do one more?
Sure.
Government has spent a lot of time defending net neutrality, so maybe I should have asked you this with respect to Florida's law, just given the breadth of that law, and why are Internet service providers, in your view, so different? And what if an Internet service provider wanted to make certain content distinctions?
Internet service providers are fundamentally different because they are engaged in transmitting data in order to make websites accessible, and that is not inherently expressive. They're certainly providing the infrastructure, the cable, the fiber optics, and the service to make sure that you can log in on your home computer and access the internet writ large. But along the way, they're not compiling that speech into any kind of expressive compilation of their own. So we would put them in the same category as telephone and telegraph companies or UPS, where you could say, sure, they're literally facilitating the transmission of speech, but they're not creating an expressive product that could implicate the First Amendment principles at stake. Now, then you might ask, okay, well, what if they want to start discriminating with respect to the service they're providing for particular types of websites? The kind of quintessential example of this is an internet service provider that decides to slow down service to a streaming site, let's say Netflix, because it wants to direct internet traffic to some other website of its own choosing, maybe its own streaming service. We think net neutrality could come in there and say you're not allowed to discriminate based on content in that way. But that's because, again, there would be no expressive speech or compilation that you could attribute to the internet service provider itself. People don't sign up with Comcast or Verizon to give them some kind of limited, curated access to the internet. They're engaging in service with those companies because they need someone physically to transmit the data so they can get access to the whole internet.
Can I ask one? I don't have to buy anything you just said to rule for your position in this case, or anything you just said on net neutrality, right?
You do not have to agree with me, Justice Kavanaugh. I hope someday, if it comes to it, to persuade you.
I'm not saying, but I just want to make sure that's walled off.
Nothing about the court's decision in this case would at all affect the net neutrality issue. You know, we think that here the platforms are engaging in expressive activity. That's protected by the First Amendment, and you can leave for another day all of the kind of conduit questions that come up in the net neutrality context.
Thank you.
Thank you, counsel.